Yes, ma'am.
You're
Thank you,
looking
ma'am.
very sharp this morning.
Thank you, ma'am.
Over to you, sir.
Good morning, everyone. Once again, my name is Manuel Lomo, and I'll be taking you on the topic that says documentation in medical legal. Documentation in medical legal. Please permit me to share my screen. Please, can you see my screen?
Yes, sir.
Okay, okay. Medical, documentation in medical legal. Documentation in medical legal. Medical legal refers to the intersection where medicine and the legal system meet. It involves applying medical knowledge, clinical findings, and scientific expertise to legal matters, court cases, or official investigation. When a medical encounter has potential legal consequences, such as determining the case, the cause of an injury, determining the cause of an injury, two, establishing the validity of a crime scene sample, or three, presenting medical evidence in courts of law. It falls under a medical legal framework. Let me try to explain further with a sample. Imagine a patient arrives at the emergency room with a deep scalp wound, claiming they accidentally tripped and fell against a table. The examining physician notes down the wound. It note the wound as clean, sharp edges with zero marginal abrasion or tissue bridging. This tells the doctor the injury was caused by a sharp instrument, like a knife, completely contradicting the blunt force profile of bumping into a wooden table. If this turns out to be a domestic abuse case, the doctor's precise medical documentation of the key piece of evidence that disprove the abuser's cover up story. Some people, because of the stigma, it may be a case of domestic violence where a husband is abusing his wife. Now, the wife may get to the place where he'll be treated and try to cover up for the husband. There are cases like that. Now, let me give another example. Consider a suspected drunk driver who crashes into another car and is brought to the hospital unconscious. The emergency room nurse draws a blood sample to test for blood alcohol concentration. The nurse immediately seal the vial in a tamper-evident bag, fills out the initial line of the chain of custody form and sign. The nurse hands the bag directly to a police officer who signed the second line of the form to acknowledge receipt. Then the officer drive it directly to the state forensic lab or the government forensic lab or any of the lab and hands it to a lab technician who signed the third line. If the nurse forget to sign the form, for example, or leave the blood vial sitting unattended on an open counter for an hour, the chain of custody is broken. In court, the defense attorney will get the blood test thrown out entirely, arguing that anyone could have altered or contaminated the sample during the unrecorded hour. And the third example that I will give is, for For example, in a criminal trial where a defendant is accused of shaking an infant, that is an abusive head trauma. A forensic pediatrician is called to the stand. The pediatrician presents anatomical diagrams, the X-ray of healing rib fractures, and retinal scan showing severe hemorrhaging behind the baby's eyes. The expert explained to the jury that this specific combination of internal injuries cannot be caused by a minor accident, like falling off a couch. By using scientific data to prove that the injuries are highly inconsistent with accidental trauma, the medical evidence directly helped the jury determine whether a crime took place or not. And now, one may want to ask the question, what is the purpose of medico-legal knowledge? Or why is this training essential? Mastery of medical legal principles serve three main purposes. One, patient advocacy and rights. That is, it ensures that patient autonomy is respected through proper informed consent and confidentiality. Two, risk management and professional protection. Risk management and professional protection. The knowledge, the medical knowledge, the medical legal knowledge, shield the health worker and the institution he or she is working for from frivolous lawsuits, disciplinary action by licensing boards, and financial ruin. At times, the health provider may have good intention while carrying out the duty, but please move to speaker.
Mr. Simon, I think. Mr. Simon,
Yes,
please
yes,
mute
ma'am.
your device, sir. Thank you so much, sir.
Okay, thank you, sir. I said the purpose of medical legal knowledge must be, let me try to hammer it again. Mastery of medical legal principles have three primary purposes. The first is patient advocacy and rights. Patient advocacy and rights. It ensures the patient autonomy is respected through proper informed consent and confidentiality. Number two, risk management and professional protection. The knowledge of medical legal will shield the healthcare worker and the institution is working for from frivolous lawsuits, disciplinary actions by licensing boards, and financial ruin. I said at times the healthcare provider may have a good intention while carrying out a job, but the fact that you are not aware of what the law says concerning an issue in your job is not an excuse. There's no excuse under the law. I don't know. It's not tenable in the court. So, risk management and professional protection to protect the provider and the institution is working for from any frivolous lawsuit or disciplinary action by licensing boards and even financial ruin. And thirdly, legal accountability. It provides the legal system with objective scientific evidence to determine the truth in personal injury, criminal or malpractice cases. Let's move on to the next slide. Meditation in medical legal. The core principles. Documentation is the bridge between medicine and the law. Documentation is the bridge between medicine and the law. A medical record is no longer just a clinical tool for patient care, It is a legal document that can be scrutinized in a court of law years after it was written. The golden rule of medical legal documentation is simple. If it is not documented, it did not happen. If it is not documented, it did not happen. Now, let me take us to the core principles. The core principles. To withstand legal scrutiny, all medical entries should adhere to these principles that I've been mentioning and standard forensic rigor. Number one, accurate and objective. It must be accurate and objective. You have to record visual observations, not emotional responses or subjective speculations. You have to describe behavior and physical findings rather than using vague labels. For example, instead of the patient was drunk, write slow speech, unsteady gait, and a strong odor of alcohol. So that one is factual. That is factual and scientific. It's different from the patient was drunk. Now, so after accurate and objective record, the next thing is legible and clear. It must be legible and clear. If handwriting is used, it must be legible. That is, somebody else must be able to read what you write down. A modern electronic health records, because today we have a lot of hospitals migrating towards electronic records instead of using paper. So clarity involves avoiding ambiguity or avoiding ambiguous, non-standard abbreviations that could be misinterpreted in court. Then it must be timely, that is contemporaneous. All notes on your chart should be written at the time of the event or as soon as physically possible. Delay entries diminish the credibility of the memory, because there's no way, as human memory works, if you delay entry, it may get to a state that you may not be able to remember everything that happened. So it's better you write everything down. The standard is to write everything down timely, as soon as it happens. So if a late entry is necessary, it must be explicitly remarked. It must be remarked as a late entry, noting both the time or the event and the time of the recording. You write down the time that it happened and the time of recording, and you the target as late entry. Then it must be enduring and unalterable. Whiteout, erasing, or deleting text is strictly prohibited. For paper, if it is paper that you use, draw a single line through the error. Write error, then initial it, date it, and write the correction. So anybody who sees it will know that you are not hiding anything. Then if it is digital records, changes must leave a clear, traceable electronic audit trail, because electronic device don't forget. So if you make a mistake, there is always a feature of your software or the software you are using. That software will have a means of correcting error. You should use it, but do not delete. Do not try to delete or cancel in a way that makes somebody to suspect that you are trying to hide anything. Changes must be a clear, traceable electronic audit trail. Then it must be chronological. Chronological in the sense that every event must be recorded in the exact sequence to establish a clear timeline or clinical judgment and intervention. It must be chronological. The one that happened last must not be the first one that you record. It must be recorded chronologically. Then lastly, it must be attributable. attributable. That is, every entry must identify who wrote it. This requires a full signature, printed name, designation, and contact details of or a secure authenticated digital signature. Now, let me repeat this core principle again. Let me mention them one after the other. The first one is accurate and objective. The record must be accurate and objective. That is, no factual, no emotional response. It must be factual, accurate and objective. Everything you record that must be factual. It must not be because you just feel like it's not something you feel, it's something that happened. What you saw is what you must be recorded at. Then the second of this core principle is legible and clear. Legible and clear. It must be legible and clear. Anybody who says it must be able to read it and understand the message you are passing across. Then thirdly, it must be timely, that is contemporaneous. It must be recorded around that time that thing happened, not later. But assuming something happened, there is a situation that occurred that will not allow it to be recorded immediately, then such a late entry must be noted. You must remark, there must be an explicitly remarked that this is a late entry. So tag it as late entry, noting both the time that it occurred, that the event occurred, and the time of recording. So both of them must be inclusive. Then I said also enduring and alterable. It must be enduring and alterable. It must be something that no one else must be able to change it. If you have, even if you have a mistake, all you need to do is to write a straight line, just a single line through the error, and write error. Initial it, date it, and write the correction. Don't white out and do not delete, and do not cross several times on it. Do not cross several times on it, so that somebody will not think that you are hiding anything. Then the sixth one, is it the sixth now? Yes, the sixth one is chronological. It must be chronological. That is, it must be recorded according to the time that that thing occurred. For example, what happened, the last thing that happened must not be the first thing that you must be recorded. So it must be recorded accordingly to the occurrence of the event. Then lastly, it must be attributable. Attributable. That is, the entry, if anyone sees it, they must be able to know who wrote it, who recorded it, and the time. The signature must be there, the name must be there, this designation must be there, and the contact details must be there. If it is a digital signature that you want to use, that digital signature must be the one that is secure, not just any, not copy and paste digital signature. Then let's go to essential elements of medical legal report. Essential elements of a medical legal report. When documenting an injury, for example, or assault, or forensic clinical encounter, the documentation must be incredibly specific. It must be specific. A standard clinical summary is insufficient. Those things that that medical or health practitioners, the way they normally put down the record of whatever happened during the time they are treating their patient, is not always sufficient for medical legal report. So it must, anytime medical activities passes the line or crosses line with law, it's shifted. The documentation must shift from just medical way of writing things down to forensic way of writing them down. So a standard clinical summary is not sufficient, is insufficient for medical legal report. Now, let's consider clinical and forensic specific. Clinical and forensic specific. Consent must be documented. Document that informed consent was obtained for both the physical examination and the physical photograph or photography stroke evidence collection. It must be documented. The consent must be documented appropriately. Then the history. Record the patient's statement of what happened in their own words, using quotation mark where appropriate. Like, for example, the patient states, "I was struck with a wooden stick on my left arm." In their own word, write it in their own word. Then, when you are doing injury mapping, you try as much as possible to describe every injury with scientific precision. For example, the type of abrasion or laceration, inside wound, punctured, or those things, etc. must be described. It is abrasion, call it abrasion, call it, or if it is inside wound, let it be documented. Then the size and shape. This is very, very important. Size and shape. Yeah, measure accurately. Yeah. Okay, thank you, Mr. Oyekashi. So you have to measure the size and shape. Measure accurately using a physical ruler. Do not estimate or use comparison like the size of a coin. Say the wound is like the size of a coin. That is not sufficient. That one may be sufficient for medical record, but forensic record, it is not sufficient. It is not sufficient. Then also, let's talk about, yes, the age, location and age. Yes, location and age. Anatomical position relative to fixed bony landmass, e.g., 3 centimeters above the lateral malleolus of the left ankle. That location is specifically documented. So you have to document the location also with precision using a ruler. Now, the age and color. Age and color. Know the exact coloration of bruises or stages of healing, as this establishes timeline consistency. For example, when you see the color of a wound, the color of a wound may show the time that thing happened. In an abusive case, maybe elderly abuse of children abuse, where you see different wounds, maybe wound on the head, then wound on the palm, and you see several wounds that are already becoming green, and another one is still fresh. That one you have to document it. Documentation will later be used. That documentation will later be used at the court that particular patient has been passing through a series of abusive activities at the hand of whosoever that is accused of doing it. But if it is not documented, then the court sees that it didn't happen at all. Then let's go non-verbal and behavioral observation. Non-verbal and behavioral observation still under elements, essential element of a medico-legal report. Know the patient's emotional state, the orientation to time and place, and any physical signs of distress or cognitive impairment. That also must be noted down. It must be documented, so that later, if anything if that thing will be used to at the court to make a decision on the case, it will be there because it is documented. It can be referred to. Let's go to chain of custody documentation. Chain of custody documentation. You call it a COC, chain of custody documentation. This chain of custody is, no, simply put, is a chronological record of who is with a piece of evidence at a particular time. For example, if a piece of evidence will pass through the hand of about 3 or 4 people, it must be documented that officer A collected this sample, or maybe collected this sample from that healthcare provider at also time. Then it must accompany with a signature of both of them, the one that is releasing it and the one that is receiving it, and the time. Then when officer A maybe give it to another officer B, then that officer B also must document it, the time and signature, before giving it to another one until you reach the lab. Even at the lab, the one receiving at the lab will do the same thing, so that if there's any broken, if the chain of custody is broken, then that one we may know who to ask question from. Then apart from that one, it will also prevent the investigator to be able to withstand scrutiny or cross-examination at the court, that nobody has ever tampered with it. So the chain of custody must be maintained and documented, must be properly documented. Physical evidence such as toxicology samples, clothing, DNA swabs, retrieved projectiles often passes through medical hands before reaching law enforcement, or even before reaching laboratory. The documentation must account for the item every second it is in your possession, to prove it was not contaminated or tampered with. Now, if you look at your screen, we have required on the form that will accompany the document. You have what we call item description. Excuse me, let me. Please look at the screen. Can you see what I'm pointing for upward? This swab stick. Can you see? Please, okay. Okay. If you look on this screen, you have something we can. You have a form on that stick, on this DNA swab stick. On it, you have the name. You have a date, you have hour, you have the name of the officer, you have some other things like that. Then you have this a sample of chain of custody form that can be used. Now, all this, if assuming this is a lab where I take sample of the blood, for example, that sample must be, before I have to seal it. I have to seal it with a tamper-proof evidence bag. Let me try to show you what. So you put it in the bag and seal it with tamper-proof seal. You have to seal it so that nobody will be able to touch it. Now, on the bag, even on this swab stick, you have something that you have form that can record, you have spaces that can record those things that I want to be discussing. Then the same thing, you have it on the bag. The bag will be smaller than this, depending on the size of the evidence. Then you have the form. So the form may be separate or may be on the evidence bag. So everyone that touched the evidence must document, it must be documented. You have a copy of it in your office. Also, they have a copy of that in their hands. Now, what are those thing, what are those details that must be inside this chain of custody form? The item distribution. So exact nature of the evidence. For example, one sealed tube containing 5 ml of peripheral blood, for example, it must be documented. Then source, whom or where the item was collected from. So the name and the name of the hospital, and so must be also documented. Then the time, the precise moment of collection, and subsequent transfer also must be collected. I mean, must be documented. Barrister, please mute yourself. Barrister Miyaki, please mute yourself, sir. Okay, thank you, sir. Now, so the custodian also, the printed names and signature of both the person releasing the item and the person receiving it also must be documented. Now, let's go to legal integrity and admissibility. Legal integrity and admissibility. To ensure the documentation rose up as admissible evidence under statutory frameworks in Nigeria, Evidence Act 2011 is what we use. This you have to keep this principle in mind. Number one, avoid jargon. Avoid jargon. While medical terms are necessary, explain them simply or ensure the context makes them clear. As judges and lawyers are non-medical professionals, so don't just use a term that the lawyer, maybe your lawyer and the judge will not understand. Don't avoid jargon. Just make it simple. Even at times, though medical terms may be necessary, but it must be explained. Then differentiate fact from opinion. Facts is not the same thing as your own personal opinion. State what you saw versus what you will infer. If you offer a professional opinion, e.g., the wound is consistent with a sharp-edged instrument. The wound is consistent with a sharp-edged instrument. Ensure it is backed by the documented physical findings. That is that if you say the wound is consistent with a sharp-edged instrument, that's a professional opinion, which is good, but it must be documented with physical findings. Do not just write it down like that, but the documentation of the physical findings must be part of your report. Then, lastly, no blame or finger pointing in the report. No blame or finger pointing. What do I mean? Never document interpersonal conflicts between staff or critics of other medical professionals in the patient chart. Keep it strictly focused on patient care and objective findings. Now, I'll be talking on some case studies. Maybe this one will help us to understand better. Case studies. The fourth case study I will title The High Cost of Poor Documentation. The high cost of poor documentation. Please, is the registrar, I hope my time is not yet exhausted. Am I still on the track? Please, help me share the time. It is the time.
10 minutes to 10.
Okay. Yes. Please, can you hear me? Can everybody hear me, please?
Yes. We can hear you, sir.
Loud and clear.
Okay.
We are with you.
Okay. Somebody is raising hand.
Yes, it is me.
Yes. Do you have a question?
Do you have a question, sir?
Yes, I may have some contributions on the case study.
It's not okay. You do. You surely do. But let's finish, sir.
Okay,
You surely do.
After.
Yes,
okay,
after.
sir.
Yes, you surely do.
Thank you.
Yes. Case studies. So let's three case studies. The first one I title the high cost of poor documentation. This is the incident. A 45-year-old male presented to the emergency department with severe lower back pain and urinary retention. The attending physician evaluated the patient and suspected cauda equina syndrome, which is a medical emergency. So the physician stated that they verbally told the nurse to prepare the patient for an emergent MRI and start neurosurgery consult. Now, the breakdown. The nurse's note simply stated, patient admitted for back pain, stable. Patient admitted for back pain, stable. There was no mention of the urinary retention, no record of the doctor's verbal orders, and no documentation on why the MRI was delayed by 6 hours. The patient suffered permanent neurological deficits. The legal outcome. The patient sued malpractice in court. The court testified they have the orders, but the nurse denied receiving them because the chart lacked any documentation of the emergency symptoms of the urgent plan. The hospital and nursing staff were held liable. Lesson: verbal orders must be avoided in non-emergency situations, and critical changes in patient status must be documented immediately alongside the provider's response. Case study 2. I will title it Informed Consent and Implied Compliance. Informed consent and implied compliance. The incident: a 60-year-old woman was scheduled for a routine laparoscopy. Cholecystectomy. That is a gallbladder removal. During the procedure, the surgeon encountered extensive adhesions and had to convert to an open laparotomy, which carry a longer recovery time and a higher risk of infection. The breakdown: while the patient had signed a generic consent to surgery form, the specific risk of conversion to an open procedure was never discussed with her pre-operatively, nor was it documented in the clinic notes. The patient woke up with a large abdominal incision. Panic, laparoscopic cholecystectomy is an operation that the incision is just very small. It's small because they are going to use a device that can see inside of that patient. So while they are doing the operation, so by the time they finish the operation, they are going to have very little wound. But in laparotomy, it will be a very big wound. So the woman woke up and saw the wound, the abdominal. She was panicked and later also she developed an incisional hernia. And now the woman took a step and sued them. The patient sued for lack of informed consent, claiming she would have delayed the surgery as she know an open position was a possibility. The defense argued that conversion to open is a standard no risk, but because it wasn't explicitly said on the consent form or in the counseling note, the jury ruled in favor of the patient. Lesson: informed consent is a process of communication, not just a signed piece of paper. High probability and high severity risks must be explicitly discussed and documented. case number 3. I titled it, The Electronic Audit Trail Never Lies. The electronic audit trail never lies. The incident: a nurse administered an incorrect dose of insulin to a diabetic patient, causing severe hypoglycemia and a subsequent seizure. Realizing the mistake an hour later, the nurse went back to the electronic health record, the EHR, and changed the documented dosage to match the correct order, hoping to cover up the error. The breakdown: the patient family filed a lawsuit. The plaintiff Anthony requested the metadata and audit trail of the EHR. Metadata is a part of electronic file that will show the time it was created. If it has been modified, it will show it. The person that modified and all those things will be there. So you can, if a file is sent to you and you modify before you send to another person, the metadata will show everything clearly. So the same thing on this software. The metadata was requested by the Anthony, was requested by the plaintiff Anthony. So the audit trail clearly showed that the nurse modified this entry 72 minutes after the medication was given and right after the patient's blood sugar crashed. Now, the legal outcome: what would have been a defensive clinical error turned into a case of fraudulent alteration of medical records. The nurse's license was revoked. The hospital settled for a massive sum, and the nurse faced potential criminal charges for falsifying records. Lesson: own your mistake. Nobody is above mistake. Document the error if there's any error. Notify the provider the corrective action for the patient and fill out the incident report. Honest mistakes are defensible, cover-ups are not. And summary checklist for daily practice. Summary checklist for daily practice. On informed consent, ensure the patient understand the benefits, the risks, and alternatives before signing. If anything happens, maybe between the time you discuss with him and you have to change the procedure, let it also be documented and signed. Status changes, that is, document when notified the provider of change what their response also was. Whatever their response also was, also document it. If anything to change at all, document it. Let everything be documented. Then refusal of care. There are cases when a patient will say, no, I don't want that, or I don't want this thing. So you have to write the description of behavior, not personal emotional label. If a patient refuses treatment, document that they have the capacity to refuse and understand the risk, including death. Now, documenting that they have capacity, is very, very important when you get to court, because if there are patients that don't have capacity to make decision, in that case, you have to take a further step, maybe to call somebody that can take that decision on their behalf. For example, a child cannot take decision on his own over his own head. So you have to, his word of parents should be allowed to take that decision. Or somebody that has mental problem or that is not conscious. So you have to document that they have the capacity to refuse and understand the risk. You have it, even including death. Then it will objectivity. Write description of behaviors, not personal emotional risk. The description of behaviors. For example, as we said the other time, don't say the patient is drunk, but say the patient you have slur speech. and unstable gait. So that one is better to describe, that is factual than to say he's drunk. Then correction, if there's any correction at all, use official addendum. Never delete or retroactively alter a note without clear labeling. Thank you for your attention. So please, Mr. Garba, your contribution will come.
Thank you so much, Mr. Olomu.
Yeah.
Yes. So, Mr. Garba, please go ahead with your question. And if there's any other person, we would take it after Mr. Garba's question. Thank you.
A question or
how are you? My auntie, how are you?
Thank you, sir. Thank you, sir.
Yes. My little contribution is towards 1 or 2, 3 cases that I come across with the real investigative processes that I found myself in, leading the investigation on that aspect. One is the case of Kano State. One lady that scissors were left on her stomach during the surgery, and which led to her death. And I was the lead of the forensic investigator on that case. And what I understood there was, I found out that there are a lot of gaps in upscaling of knowledge of medico-legal in most of our law enforcement agents, and most of our judges, most of our Ministry of Justice, state councils. That issue gave more light for those that are part of the investigation, and it will take off most of the burdens that are attached to the medico-legal investigation. Mr. Olomo, you have done a lot, and I thank you very much for your kind contribution, time, and counseling. Secondly, is a case, yes. Secondly, is a case of mine. I will not mention the hospital, but I will mention the scenario that really happened. There was a time when I was not well, seriously. I was at that hospital, and thank God that that hospital use health information system. That if you come, you are going to show your PID number, and they will give you a token with the name of doctor that you are going to attend or will attend you, and the time. When I came there, that doctor was arrogant to attend me. He had been attending some patient, and I asked him, look at my token. And you have been attending some people there after me. I will not see you. I will not attend you. And I have all the possible right for me to be attended, not knowing that all the record were there. The time that I went to the hospital, the time that I was issued with a token, and that day he didn't attended me. He didn't attend me. I went to another hospital, chemist, and get some medication. Had it been I die, that record, the token that I were given, I am very much sure that Mr. Olomo will come all the way from his location to Kano in order to defend me. And I prove that he was wrong, and he was not medically trained on medico-legal. I found out that the hospital had never taken any medico-legal training. That is where I came on with one of the former CMD of Amine Kano Teaching Hospital, we train them on Medico-Legal. The essence of that is, I want tell our society, meaning this forensic society, to make more and more time and more of such kind of workshop for law enforcement agents, even legal practitioners, state councils, and judiciary in general. We have a lot of gaps. Thank you very much, sir.
Thank you, sir. Thank you, sir. Appreciate you.
Thank you.
Hello, I don't know whether I can be given the permission to make an observation, sir. I'm sure we'll
Yes, please.
again.
Yes, please go ahead.
You are
This
welcome,
is the
sir.
time for discussions and observations, questions.
Thank you very
Go
much.
ahead.
Thank you very much, ma. I would like to register my very sincere appreciation to our facilitator, our mentor, Mr. Olomo. He has done justice to the topic medico-legal. And it's one of the areas that we need to actually keep abreast. As a rider, sir, to what Madam Aminu, Mr. Aminu Muhammad have said, actually there's a serious gap presently in our context in the Nigerian society concerning this education, this awareness of medico-legal by stakeholders. So I'm also calling on the society to try as much as possible to extend collaboration, especially with the relevant stakeholders, the law enforcement agencies, the judiciary, and also respective medical practitioners, maybe institutions, medical institutions like teaching hospital, so that from time to time we organize seminars, sensitization workshops, so that these issues revolving around medico-legal will be discussed and we'll be able to come up with progress report with communique that will enable us to progress in this area. So that's just my suggestion, and I wish you well, sir. May God bless you and enrich you the more in the knowledge of forensics. We have really learned a lot from you, sir. Thank you very much.
Thank you, Ogami. Thank you.
Thank you so much, sir.
Thank you, ma'am.
Do we have any other question, observation, comments?
Yes, from Mr. Tunjolaleye.
Thank you very much. Can you hear me?
Yes, sir.
Yeah, first,
Yes, sir.
Please allow me to sincerely thank and appreciate our presenter. He's done a very wonderful job. Thank you very much. Secondly, just to align with what our previous speakers have said, I would have expected the target audience for today to be mainly health professionals or people who work in the health industry, because as one of the speakers said earlier, there is serious gap. I look back at what happens in hospitals in Nigeria, particularly the case of the arrogant doctor, which runs contrary to professional code of conduct and code of ethics for health professionals. These are things that should be brought to the forefront and dealt with. And I want to say again that when we talk of medico-legal, medico-legal just does not sit with health professionals alone, but even with people that work within the health industry. A case, UK Supreme Court case of Danley versus Croydon Health Services in 2018 found the receptionist liable because Mr. Danley presented at the accident and emergency with a blunt injury to the head. The receptionist, instead of allowing the triage nurse to triage this gentleman, told the guy that he would have to wait for about 3 to 4 hours before being seen by a clinician. The guy could not wait because he had intense headache and went home. And eventually he suffered irreversible brain damage. And the Supreme Court held that although the receptionist is not clinical, but the fact that she offered an opinion, she was liable and guilty. So that's just to tell us that it is the issue of medico-legal does not just, it stands with the gate man at the hospital to the lowest paid person in the hospital. So that's one. Then the other thing I would like to say, just to as a matter of contribution, is that according to Mr. Olomu, one of the characteristics, and which I would like again to just to emphasize and possibly add, is the use of medical jargons. I know he spoke about non-use of standard abbreviations. We are fond of, clinicians in Nigeria are fond of using medical jargons, even when talking to patients, even when obtaining informed consent. You need to tell the patient at the point you are obtaining that consent in a language that the patient understands. Now, let's take the case of the lap cholecystectomy that was converted to laparotomy. There's every possibility, and I stand to be corrected, that the clinician would have told the patient that in case we cannot remove this thing laparoscopically, we may need to open you up. Instead of using that layman language, they probably would say we need to convert to, and when you say that, a layman, a patient who is in pain, who does not understand your medical jargons, would give you consent, but it's later that you will realize what you were saying. We've seen a lot of cases, you ask patients, have you eaten today? They say no, but when the patient comes on the table, you see patient regurgitating. That is by the way. So again, for a clinical practitioner, I would want to counsel that, which we tell our junior colleagues as well, make sure you document what you saw, what you heard, and not an hearsay, not what somebody says, and you now want to think and write that as factual. So you have to be objective and not sentimental or emotional. This is to our female clinical practitioners, especially when it happens, when something happens to a woman, maybe presenting with a case of domestic violence. The first thing, they will become so sentimental and emotional that it will reflect in their clinical documentation. So I rest my case. Thank you very much.
Thank you so much, sir.
Well said, sir. Well said. Yes, well said. Thank you very much, sir.
Mr. Olomu Emmanuel, thank you so much. Yes. Do you have comments?
Somebody's raising up.
All right. Mr. Oluf, is it Mr. Olufemi Likolo? Likolo. And Mr. Dakwaki Oshun. Dakwaki Oshun. If you can hear me, kindly over to you, Mr. Dakwaki Oshun.
Thank you very much. I just wanted to add to what the last speaker said, my brother from Kano, that sometimes doctors are overworked, they're under pressure, and it may not necessarily be a matter of arrogance that makes a doctor behave badly. It could be that he's just under pressure. And I think it is important that medical facilities also educate their staff. And if you are tired, if you're under pressure, it's better to withdraw from service that day than create liability, because every wrong step, as you can see right from the security man or even the receptionist, can put the hospital in trouble. Thank you, sir.
Thank you so
very much for your contribution. You are right, sir. You are right, sir. Thank you, sir.
All right. Mr. Olufemi. Mr. Olufemi Likolo, are you there? Likolo, are you there? I hope I'm pronouncing your name correctly. My apologies. All right. I think I don't know if he can hear us or he's probably away from his device. Thank you so much once again, Mr. Olomu, and thank you everyone.
I'm Maran, ma.
Oh, okay. Please go ahead, sir.
I'm sorry, ma. Another call just came in, so it disturbed my. Yeah. Thank you, ma. First, I want to appreciate our presenter, my brother, Mr. Lomu. So, what I just want to say is that I noticed that some of these medical practitioners, when they are giving consent form like that, I expect those consent form to be in duplicate or to be in 3 copies, because sometimes when the maybe the patient maybe sign a ballot document, they may not really understand what is in. They just sign because of the condition, maybe because of the medical condition that they find themselves. Like I remember maybe about 3 or 4 weeks ago, I took my mother-in-law to an eye clinic, and maybe they wanted to give her injection on one of the eye, because she has complained that maybe she find it difficult to see, and they said that maybe and the cost of that injection is very, very high, very, very more than $500,000. So what I just want to say is that that in that consent letter, what they put there, they said that maybe if the person that want to take the injection does not understand maybe the language, maybe somebody that come with such person should interpret those things to the person. You understand? So now the form now came in one, because one of the conditions stated there is that maybe after taking injection, that maybe some of the adverse effects on that is that maybe blindness is one of the conditions there. Even myself, I was scared, because I was there, the one that followed her to the place. You understand? Now, why am I saying this is that form was just only one. It's supposed to be at least 2 copies, so that the person will also go home with a copy, so that at least the person will know that, okay, this is what I've signed before a maybe treatment was done. So that's just my observation concerning maybe this consent form and the jargon of the thing that our speaker spoke about. Thank you very much, sir.
Thank you so much, sir.
Yes.
Mr. Olomu, do you have anything you want to say concerning all the comments and observations?
Yes, thank you all for the comments. Specifically on the issue of reaching out to stakeholders, we've started, but we started, but we do more. Even presently, we are working seriously to we are building a curriculum for 400 level students, 400 level students in medicine, and also for students of law, because the medico-legal is not just about the people in the medical arena alone. So we are working, we want to try as much as possible to build a curriculum for them, so that before they go into the medical world, they are already inducted into medico-legal. So we are working on that one. Thank you very much. And also, we do more of this kind of program will still come up, and I can assure you, by the time we have the next one, you have more participants than this.
From my end, Mr. Olomu has books on Amazon. The books he has written on various topics, on handwriting analysis, on various forensic investigation topics, and you can get his books on Amazon. But very soon, these books will be available locally for us to purchase. While we wait for Barrister Queen Oniwon, do we have? I think we should have like a discussion, maybe cases that we've gone through before, in line with what we've discussed, what Mr. Olomu had discussed earlier. Do we have like practical cases where we want to share, just like Mr. Mohammed shared? Mr. Tunji Olale.
Yeah, thank you very much. Can you hear me?
Yes, we can hear you, sir.
Thank you. So I just would like again to talk about what we have spoken about before, and which is the issue of documentation in healthcare practice. Looking back at my own experience when I was still in Nigeria, I realized that we still have a long way to go in terms of documentation and in terms of comportment. Yes, it is true that the society is becoming more aware and more litigious. But even at that, we still have a lot of gray areas in Nigeria that needs to be really addressed. And that is where I would want to enjoin the organizers of this webinar and the board of forensic investigators to, as somebody had alluded to previously, work in conjunction with all the regulatory professional bodies in Nigeria, like the Nigeria Medical and Dental Council, the Lab Council, Pharmacy Council, the Nursing Council, etc., to sensitize and their members, because there are so many loopholes there. Even when investigators come in, do you take a case of people issuing medical certificates indiscriminately? There was a case of somebody who gave another person excuse duty. We call it excuse duty in Nigeria. A young serving doctor, a copper, wanted to make quick money, gave the person, not knowing that the person that he had given excuse duty had died 2 days before. So it took a lot of investigations to be able to prove the fact. And of course, the guy had to go to jail and he had his license withdrawn. And we have a lot of other cases like that. So we need to sensitize people in the clinical area. Let them know that now things have changed. In the past, a lot of people did things with impunity without repercussions, because in Nigeria, particularly in southwest Nigeria, we usually have, when a death occurred, people will come in and the family will be quick to say, doctor is and that will be all. Not leaving room to look at and explore if there had been negligence on the part of the professionals. So I would want to, while commending this society so far for, I've gained a lot within this short space of time. I've joined them. I've joined you guys. I would want to enjoin you that please do not relent. Do more, reach out more, collaborate more with people, even if it means bringing issues and series to hospitals. Not only teaching hospitals, general hospitals, district hospitals, primary health centers, local governments, collaborate with them and let them know and let them be aware of the medical legal implications of their practices. Thank you very much.